Welcome to the Libertarian Counterpoint. I'm Richard Fields. On the program today, John Cameron, the author of Rewire and Rekill, and this is going to be an all-PLF program. He's a development officer at Pacific Legal Foundation. Also, Jeremy Talcott and Johanna Talcott, who are PLF College of Public Interest Law attorneys. And yes, brother and sister. Who's oldest?
I am.
Who's strongest?
Me. Probably her.
Welcome to the show.
Smartest.
Who is the best lawyer?
To be seen, I guess.
Yeah.
The race is on.
So we'll find out tonight. We'll see who can talk about NFIB versus OSHA the most persuasively. Jeremy, you start.
Sure. So this is a case that PLF is involved in. This really involves something called the Fairfax Memo, and this involves an OSHA interpretation of a regulation. So what's happened is that Richard Fairfax, who's chairman at OSHA, he's written this letter that essentially says, going forward, when there's complaints at a business, we're going to allow the employees who've made this complaint to identify an authorized representative, and that authorized representative can then accompany OSHA inspectors onto the property, looking at the business, looking to see what the nature of the potential violations are.
Now, OSHA, that's Occupational Safety Health Administration.
That's
right?
correct. That's
okay,
right.
So they're looking for dangerous stuff.
Right, exactly. And what really has changed with this memo is the fact that now, instead of an authorized representative being understood to be a union employee with an employer who has a collective bargaining agreement, they're allowing union employees who have nothing to do with this employer or these employees to become an authorized representative.
In other words, somebody that doesn't even work there?
That's correct.
Wow. So they're saying a union organizer can come on to a job site in a factory or whatever where he has never set foot before to accompany the OSHA inspectors and try to make trouble.
That's right, and this really is, it's a handout to the unions. It allows them to come in and get information at an employer to inspect the premises, to potentially get involved in some attempted proselytizing, trying to then engage in a collective bargaining agreement. That's kind of what we're seeing after the fact. There's a real incentive here for unions to go find businesses that are not collectivized, start filing some complaints, find an employee who's willing to say, oh, I'll file a complaint about the hours, about some aspect of safety, chemical spills, things like that, and I'm going to authorize you to now be my representative. The union representative sends the letter to OSHA and basically says, from now on, you talk to me, and when you go and enter onto this business, I'd like to go along with you.
So the person who did this was an administrator at OSHA, federal agency?
Yeah, and what's, this really gets into kind of the legal aspect of it. What's interesting here is, of course, Congress passes the statutes which authorize these agencies. The agencies then create regulations to interpret those statutes, and then this is even one more step removed, which is an interpretation letter, which is interpreting the agency's own regulations. And unfortunately, our courts have created some doctrines of deference. Many people, especially anyone involved in the law, has probably heard of Chevron deference, which is deference to those regulations. But those regulations still have to be passed through notice and comment. There's also our deference, which is giving deference to just these opinions, these interpretations. So really, an interpretation letter such as this can be passed with no public review, and it can also be changed, again, then with no public review. So it allows these agencies to change their position very easily.
Okay, so what's the underlying law that allows safety inspections in the first place? What's the language of the law, roughly?
Well, for this, again, you get a couple levels. So the first level is the statutory grant of authorization. OSHA, you may go enforce safety in employers. The regulations are saying we allow an authorized representative to accompany the inspector, and now it's this interpretation letter that is
before the interpretation letter. Who was the authorized representative? Was it somebody that actually worked at the same business, or was it somebody from management, or what?
Yeah, for many years this has been understood to be an employee, and when it talked about an authorized union representative, that was understood to mean at employers who were engaged in a collective bargaining agreement. So
Somebody that actually worked there.
yes, yeah.
Right,
And so
okay.
this is a total shift from what the previous kind of precedent had been.
And so it was done entirely to give unions entree to non-unionized workplaces in order to collect evidence to proselytize to unionize them.
Well, I mean,
Or at least that's what it would
right.
appear.
We can't really speak to the
Motive.
actual motivation,
Yeah.
but it certainly
That's the effect.
seems like this is the end effect exactly, is that now unions have a...
I'm sure it's an unintended consequence.
Okay, so
Yes.
Who could have ever predicted?
What's the legal argument against doing this kind of regulatory overkill?
Well, so the argument that's going to be brought up in this lawsuit is the fact that this type of a interpretation or something that changes the underlying regulation really needs to be done through that notice and comment process. That gives the public an opportunity to respond. It forces the agency to explain their reasoning, and it goes through the proper channels.
So in other words, it becomes something other than just because I say so.
Exactly, and that provides stabilities for employers as well. That prevents the next administration from just immediately backtracking. It requires these agencies to go through at least some sort of a process, and all this is governed by the Administrative Procedure Act, which is a whole nother topic. But of course, that kind of creates the framework that allows all this to happen. So,
Question: doesn't this kind of violate due process? I mean, I guess due process, you would be tried or convicted or fined or something. There'd have to be some kind of ramification. But I don't know. Maybe is it borderline due process, or am I just kind of reaching for law here?
well, there's an argument there certainly that there is process that's due when an agency is going to be impacting your rights. So,
And you talked about Administrative Procedure Act that I don't know if we're going to talk about, but doesn't that spell out that all of these things can't be done on a whim? There has to be comment, there has to be posted, posting whatever the proposed thing is. It has to be reasonable. It has to be easily understood. I mean, there's a bunch of rules to follow the APA, right? And this looks like, on the face of it, again, I'm not a lawyer. They are. Seems to me that it just throws that out the window.
well, the APA does allow for interpretations. So it is expressly mentioned in the APA that interpretations are allowed. There's really three different processes. There's formal rulemaking, which basically no one uses because it requires a full hearing. There's informal rulemaking, which is still quite formal, involving this notice and comment, time for the public to respond. The agency must respond to that, and then it all gets published in the Federal Register.
And this is what, whim? Is there a little third thing? This is whim?
And the third thing is interpretations. There's a lot of different ways that agencies can engage in interpreting their statutes and regulations. Sometimes that can come through adjudication, this sort of quasi, it's almost like a court, but it's run by the agency.
So you're talking about administrative law procedure?
Yes. So there's these adjudications, which are ways that they kind of interpret their regulations, and that can kind of create almost a sort of precedent. And then there's these interpretation letters, which are...
Where is the case right now?
So right now, this is, I believe, on appeal. This
From?
is, I'm not sure. This is Damien's case.
Oh, okay.
PLF attorney, and
Yeah.
I don't know exactly where the state is. I
Oh, okay.
believe we're on appeal on this, but I could be wrong.
Appeal
there.
in the federal courts?
Yes, that's right.
Okay,
This
so
is
it would be
this is
appealed to
a
the
federal
next-
court in Texas. That this
Oh,
is being-
okay, so it would be a different circuit.
Yes, that's
Well,
right.
that's good.
I think another important thing that's implicated by this case is the fundamental property right to exclude people from your property. And it seems like this is a way for the unions to be able to get people onto the property of employers who might not want them there.
And perhaps a Fourth Amendment right as well, search and...
I mean,
Fourth and
I don't-
Fifth.
I don't know. I don't know the case well enough
Well,
to say, but it definitely is
in
implicated.
California, that's kind of been thrown out of the window, and I know somebody's getting ready to challenge it by a regulation. I guess Cesar Chavez was involved in it 40 years ago. So they've kind of said that, at least in California, in contrast to the Constitution saying you can't do it, I don't know why nobody's challenged it, that these yahoos can go on somebody's private property and can organize and can, whereas in the rest of the country, I haven't seen them able to do this, I would think in the right-thinking state of Texas, pun intended, that this would be a really hard sell for these union folks. I'm hoping.
Moving on to a ESA, Endangered Species Act law. It's the California Sea Urchin Commission. It is a ESA, right?
Yes.
Versus Jacobson. What's that all about, Johanna?
Well, this is kind of an interesting case. It's not directly under the ESA, but it instead involves a statute that codified a really important compromise between the U.S. Fish and Wildlife Service and the fishermen that work and operate in Southern California's waters. So just by way of a little bit of background, in the late 80s, the U.S. Fish and Wildlife Service wanted to expand the range of southern sea otters. They've been an endangered species since 1977 and had been kind of slowly making a recovery, but in the early 80s, the service was concerned that the entire species was at risk because from a catastrophic oil spill, because their numbers were small and their range was so limited. So
this was the Santa Barbara oil spill?
I assume so.
Okay.
Yes, I'm not terribly familiar with it, but yeah, because they're essentially all of the otters were in one location, so one spill could theoretically wipe out the whole species. So what they wanted to do was establish a whole new population of sea otters far enough away from that parent population that one oil spill couldn't impact both populations of sea otters. So the service developed a program, a translocation program, where they would move sea otters from up north to a channel island down here off south of Point Conception, and they needed authorization to be able to do it because,
Go ahead.
Because trapping and moving otters is prohibited under the Marine Mammal Protection Act. So even the Fish and Wildlife Service had to get congressional authorization to be able to conduct that program.
Well, I'm confused. A southern sea otter and the northern sea otter are the same species, but they're endangered simply because of their geographical location?
I don't know too much about the taxonomy of sea otters, but
they're talking about moving
the
from north to south.
taxonomy, that's good. Yeah.
The southern sea otter is considered a distinct subspecies. Or
But is it
species of
any
otter
different than sea
than a
otters off of
northern sea.
Monterey?
No. So that's still the California sea otter, but I think it's compared to sea otters up in Alaska or Washington State. That might be a distinct. But don't quote me on that because I'm not 100% sure about the sea otters. But the parent population would have been up near Monterey, northern California, and so in
it would
order
be the northern southern sea otter, the southern northern. Sea
now you're
otter.
just confusing me. So anyway, so they needed congressional authorization in order to be able to move these sea otters and try to establish the new population. And Congress did pass a law, Public Law 99625. And as I said, it codified a compromise because the sea otter translocation program was controversial because sea otters, fun fact, are voracious predators of sea urchin and shellfish. And if even a small...
I love abalone.
They do, and abalone. So they'll move into an area, even a small population of otters, and they can virtually decimate the entire shellfish population. And so naturally, the fishermen who earn their livelihoods in this area were really concerned about bringing sea otters into the areas where they work and fish for sea urchin and other shellfish. So again, that law...
Sorry, I wanted to say it's very shellfish of them. I guess I did say that. Go ahead.
But the intent of that law was to promote the recovery of sea otters and help the service establish that new population, but also balance that against the interests of the fishermen in Southern California who were concerned about their livelihoods being in peril. And so it essentially said, yes, the service can establish new population of sea otters around San Nicolas Island, which is one of the northern Channel Islands, and around that area, from Point Conception all the way to the border of Mexico, there will be established a management zone. Within that management zone, the service would be required to move otters out of the any otters that strayed into the management zone, move them out or move them back to San Nicolas Island. And they would also have to provide for an exemption to the Endangered Species Act and the Marine Mammal Protection Act. Under both of those acts, there's a very stringent take prohibition. Take is pretty much anything you could do to a sea otter: killing one, capturing one, getting too close to one, harassing one,
Hurting its feelings.
hurting it, looking
ought to
at
not
it
do
sideways. And so naturally, fishermen were concerned that if there were going to be more sea otters in the areas where they're working, they would be subject to potential take liability under those acts. So that law, in addition to creating the management zone, provided for that exemption. Fast forward to now, the service has decided that the translocation of the sea otters was a failure, and they want to terminate the management zone protections, and they purported to do so in 2012. But what we're arguing in this lawsuit, brought on behalf of the California Sea Urchin and other plaintiffs, is that that is in violation of the statute that Congress first passed to authorize this program in the first place, and that the take exemption and the management zone protections need to stay in place in order to protect the livelihoods and the fisheries of Southern California.
So it's really a case of the federal agency saying, we don't like the law, so we're going to ignore it and reverse it.
More or less, this is another issue with what Jeremy was mentioning about the agencies overreaching what they're authorized to do. The Public Law 99625 authorized the service to develop a program, but it said that if they're going to develop this program and if they're going to translocate sea otters down to San Nicolas Island, then they also had to include those management zone protections because it posed such a threat to the fisheries of Southern California. So, the service undertook that program, and they did what they were authorized to do, but to do that, they needed to keep those management zone protections in place. And at present, there is a population of sea otters still at San Nicolas Island. I've heard around 100 or more that are living there and thriving and expanding. And sea otters are continuing to move into the management zone where people are trying to work and fish, and eliminating populations of shellfish that make it very difficult for people to be able to earn their living.
Cool.
And so where does it stand legally? What's the lawsuit?
We have kind of gone up and down to the Ninth Circuit, and it was initially the district court dismissed the case on a statute of limitations ground. So it went up to the Ninth Circuit, and the Ninth Circuit said no, it was not time barred, and the plaintiffs could bring this challenge, and instructed the court on remand to address the merits of the case, whether or not the service's purported termination of the management zone does violate Public Law 99625. So right now, we are back in the district court, and we're working on a motion for summary judgment to try to get the court to finally resolve this question and let the fishermen know whether or not they can continue to work and not have to worry about take liability.
I take it sea urchins are not endangered.
I'm sorry now?
I take it sea urchins are not endangered, or other shellfish.
They're not endangered. Abalone previously was fished in Southern California, but in 1997 there was a complete prohibition and a closing of the abalone fisheries because they had been reduced so much. So another one of our clients is the California Abalone Association, who one of their purposes is to be able to make it so that those fisheries could open up again, so that abalone could be harvested commercially in Southern California's waters, but to do it in a sustainable way that makes it so that it can continue into the future.
Did you know how the abalone population has it recovered in Southern California?
I really don't know.
Because I know, at least in the Monterey area, where people take, not to be confused with taking, people harvest, hunt, fish abalone. You can't do it with scuba gear. You have to do it with
Free diving.
snorkel or free diving. You can't use any equipment. So when you talk about commercial fishing, I don't even know if you can do commercial there. It's
not commercial. I think it's only sport abalone diving
there.
is what I understand.
Yeah. So there's no
I have
commercial
heard that.
there. So
Right.
what do they? But never mind. We're beating this thing to death. But so the take thing that you brought up is really interesting because once in a normal area where there's no, where they haven't put this take thing aside, there are really stringent requirements, and the take requirements are so stringent in most cases they're an outright ban on the activity because they'll say like you can do this development and build 1,000 houses as long as you don't take more than 1/4 of one kit fox kind of thing.
Right.
So, which means if you scare one, you violated and you're subject to fine and blah blah blah, or else
Exactly.
you can't get a permit to do it. So it's pretty scary stuff.
The service has defined take very, very broadly, and as you said, it can really encompass just about anything. So if this exemption doesn't stay in place, that implicates virtually any activity in Southern California's waters getting too close to a CI.
Yeah, if you're driving your
scaring.
boat
So
over,
you might not even be able to take your sailboat out, in other words.
Yeah, potentially.
And that can lead to both fines and potentially even criminal liability, right?
Exactly, and for an independent fisherman who earns his livelihood diving for sea urchins every now and again, that could completely decimate his business.
Moving on, Gaddy versus the Georgia Department of Revenue, school choice case. Johanna, what's that all about?
This is another case that PLF is involved in as an amicus, a friend of the court, and will be drafting a brief encouraging the Georgia Supreme Court to uphold a tax credit scholarship program. What Georgia State did was develop a program where individuals and organizations can donate to scholarship programs and in return get a certain percentage of that tax credit as a tax credit, and and those scholarships can then be used by families to send their children to a public or a private school of their choice,
including religious schools.
including religious schools, and that's one of the issues at the crux of this case. Some anti-school choice activists have filed suit against this tax credit program, arguing that it violates various provisions of the Georgia Constitution, but one of them that it violates the Establishment Clause of the Georgia Constitution, in that by allowing these tax credits to be used towards religious schools, that's an improper entanglement of church and state. The bottom line is that courts all over the country have consistently upheld programs just like Georgia's, in Florida, for example, and in New Hampshire. And the Supreme Court has said that when parents use money to choose a school, including a religious school, it's not the government choosing religion. It's not the government making that selection. It's the individual. It's the family, and they're making a choice that works best for them, and they should be free to do that.
Isn't there there's a similar challenge in Colorado as well, I think?
There was,
yeah.
and I think that too, the Supreme Court said it does not violate the Establishment Clause.
Okay, and so this is a case, what, at the appellate level at this point?
Yeah, it is, I guess, up for oral argument at the Georgia Supreme Court in January.
Okay, okay. Next case, 616 Croft Avenue versus West Hollywood. I have no idea what that is. Jeremy?
So this is a California case. This is one that's going to be going before the California Supreme Court. And this is a challenge to an affordable housing ordinance, also called an inclusionary housing ordinance. And what's really at issue in this case is a couple of developers who applied for a permit to demolish 2 houses in West Hollywood in order to build an 11-unit condominium. So this is someone who's actually, in their own way helping solve some of the housing crisis here in California by increasing the number of units that are in a small footprint. It's called infill development. And the city of West Hollywood charged them $500,000 in an affordable housing in lieu fee. So essentially what's going on is if you're going to build any housing unit that has more than 10 units, you have a choice. You either set aside some of those units that are then going to be subject to rent controls, price controls by the city, or you can pay what's a huge fee. Again, $500,000 for this developer.
That's like $500,000 or $445,000 per unit. Something
Yeah,
like that.
it's crazy. And again, this is the people who really are solving problems that the cities in California and the government in California has caused of making housing so expensive by creating some new units, and they're being charged for something that really they haven't caused. And where that starts to run afoul of Supreme Court law is some of the PLF cases like Nolan v. California Coastal Commission that require an essential nexus between what the government demands of you and the harm that the government is trying to prevent. Again, here, I don't think anyone can argue that the developers caused the affordable housing crisis in California.
And they're actually solving it by replacing 2 houses with 11, right?
Exactly. They're in a small way helping. I think this is in the city of West Hollywood, so it is an 11-unit condominium, and those aren't going to be cheap by any standard. But again, it's still in a small way
Cheaper
solving
than
this problem.
2 Hollywood mansions.
Cheaper than 2 houses, exactly. So, if the government wants affordable housing, they have ways to solve it, and the best one would be the government taking a step back from all the...
And kind of letting the market take care of things?
Absolutely.
So couldn't we show a significant nexus between government regulation and the lack of housing and charge the government that fee? I mean, because they basically, anybody
be
who
nice.
can rub 2 IQ points together knows that the problem is the government basically limiting supply, so all of the rich donors in the area can watch their housing prices go up. That's what's going on.
Even the White House recognizes that it recently came out with a report discussing land use and zoning regulations and its tremendously negative impact on the price of housing and how much it's limiting the ability for people
What,
to
our White House?
And,
believe it or not.
It's like the one
if your
in
land happens
DC?
to be if your land happens to be on the coast, you've got another thing to contend with, the California Coastal Commission.
That is
I understand they're now in the business of regulating environmental justice. What in the world does that mean?
Well, that's
Whatever you want it
a
to
great
be,
question.
Richard.
It's whatever allows
Whatever
you
it
to regulate
means.
anything and everything. That's if I've watched some of the California Coastal Commission hearings, and that's just been the hot topic is environmental justice. It seems
What are they actually saying is environmental
Who
justice?
knows?
yeah,
Good
it's-
habitat for spotted owls. What?
No, really where they're trying to make a new connection here, I guess, or a new thing for the California Coastal Commission to be involved in is they want to make sure that use of the coast is inclusionary, that disadvantaged communities have the ability to use the coast.
Increasing
Like-
access.
like, so Republicans.
So this is
Yeah.
social justice for
Right.
Making sure that
poor-
the environment
Okay.
is available to
Yeah,
all
everybody.
classes
Okay,
and
got
all
it.
types of people.
Beaches, right, are the kind of the big one that they were talking about.
Beach access is a big one. If you're in any way opening some sort of access, now the Coastal Commission is grilling people, well, how are you going to ensure that the people who come here are not just wealthy people who already live on the coast, but how are you going to draw people from disadvantaged communities? I mean, this is impacting everyone. At the last hearing, the Monterey Aquarium was grilled on how they were going to ensure that they increased minority access. And this is, someone who already does tens of thousands of school kids a year.
That's the show for this week. We'll see you again next week. Same time, same place on the
Good show, Richard.
Libertarian Counterpoint. We're on the web at www.accesssacramento.org at 8 p.m. Thursday noon, Friday 4 a.m. Saturday.